Constitution Basics. An outline of the Constitution and how the voice to Parliament fits in. Before we make a change to the Australian Constitution, Australians need to understand what the purpose of the Constitution is, what the key features of government are, including separation of powers and division of powers, and why a referendum is necessary to change the Constitution. When we understand these fundamentals, we can look at the proposed amendment and make an informed decision about whether we will agree to make changes to our Constitution. The Constitution is a legal document setting out the basic laws for the Government of Australia. After a series of conventions in the 1890s, the Constitution was created by representatives of the 6 colonies. Before it came into effect on the 1st of January 1901, its terms were approved, with one small exception, by the people in each colony. Western Australia is not in the original preamble proclaimed on the 9th of July 1900, as they were originally reluctant to join the Federation, and did not hold a referendum on the question of Federation until the 31st of July 1900. Although our Constitution was given legal effect by an Act of British Parliament, in reality, the Constitution is a document that was conceived by Australians, drafted by Australians, and approved by Australians. The British Parliament no longer has any power over Australia, and the Constitution's power, as a fundamental law of Australia, relies on the Australian people's decision to approve and be bound by the terms of the Constitution. The preamble is a concise summary of the rationale and principles behind the Constitution and is often symbolic of the history and aspirations of a new nation. The Australian Constitution highlights the colonial origins of the Act, that is, where people of the separate and self-governing colonies, now called the states, agreed to join together to unite and become a new nation, the Commonwealth of Australia. The Constitution was created on the assumption that the rule of law would operate throughout Australia, with equality before the law deeply ingrained in it. The Constitution requires that the government obey the law and provides checks and balances to ensure that occurs. The Constitution is deliberately structured into chapters to create a legal and political system that governs Australia. Rather than one central body holding all power, the Constitution has 8 chapters to spread power between the federal government and states, called the division of powers, and between the legislature, executive, and judiciary, called the separation of powers. The division of powers ensures that all power is not held by one level of government. Sections 51 and 52 limit the areas that the federal government can make laws about, called exclusive powers. These are predominantly national issues such as defense and immigration. The states can then make laws on all those areas not covered in the Constitution. We refer to these as residual powers. These include state issues such as health and education. As state governments are generally closer to the community, they are able to deliver services that meet the needs of their community. If there is any conflict between state and federal laws, the federal law will override the state law. The Constitution is also structured to provide for separation of powers between the legislative power, those who make the laws, including our members of Parliament who are representatives elected by the people of Australia, executive power, those who put the law into effect, which includes those who administer the business of the government, and judicial power, those who interpret the law and conclusively determine legal disputes, which includes the courts. Each of these powers must operate in accordance with the Constitution. By separating and putting limits on power, it ensures each body works within their area of responsibility, as defined within the Constitution. This provides checks and balances to avoid power being held by one single body, and is instead distributed across the 3 bodies, which ultimately ensures that it is the people who rule. The High Court is established in Chapter 3, as a final court of appeal, and to interpret the Constitution. The High Court is a powerful check that ensures the legislature and executive act within their roles as defined by the Constitution. In particular, Section 75 requires officers of the Commonwealth to act within the law. This is a key element to the rule of law, where all people, including those in power, must follow the law. The High Court also ensures any laws made by the legislature are consistent with the Constitution. These disputes may be between governments, or between citizens and governments, over the limits of the powers defined in the Constitution. The Constitution provides for the two pillars of an independent judiciary: tenure and conditions of service. By outlining the remuneration and length of service of the judiciary, it ensures the judiciary is not easily influenced by those in government and safeguards the impartial independence of the courts. The Constitution is the people's document, so it can only be changed by the people. It would not be good for the stability of our nation and system of government if those in power, such as the government of the day, could easily change the Constitution to further their own political or personal interests. As a result, the Constitution has outlined a specific process that is required to get the consent of the people before the Constitution can be changed, known as a referendum. The required elements needed to change the Constitution are: first, the proposed change must be passed by the majority of both houses of federal parliament. Then, the majority of Australians must vote in favour. Finally, the majority of 6 states must have a majority of voters in favour. Changing the Constitution is deliberately a difficult process to protect our foundational document and ensure that it is the people of Australia who decide whether they are in favour of making any changes. The Constitution has only been changed 8 times since its introduction in 1901. The last change occurred in 1977. The Australian Constitution is a mechanical document that outlines the allocation of power and responsibilities between the federal and state governments and sets up the 3 branches of government. Because the creators of the Constitution believed our rights were best protected by a parliamentary democracy, it does not contain a Bill of Rights, and only contains a few express rights, such as the right to trial by jury for offences against Commonwealth laws. Some implied rights are also identified. It has been proposed that the Australian Constitution needs amending to recognise and respect the Aboriginal and Torres Strait Islander people, and to provide a permanent mechanism to listen to Indigenous peoples about matters that affect their lives so they can improve their outcomes and close the gap. The question that will be put to voters in the 2023 referendum is whether to vote yes or no to adopt the proposed law that will alter the Constitution by inserting a new chapter, Chapter 9, Recognition of Aboriginal and Torres Strait Islander peoples. The Voice proposal will not include a change to the preamble, like the failed 1999 referendum, that proposed to recognise First Australians in the preamble to the Constitution. Instead, the Voice will be a separate chapter in the Constitution, establishing a new body called the Voice. This new body will sit alongside other major institutions established by the Constitution, such as the Parliament, Executive, and Judiciary. The Voice will have the power to make representations to the Parliament and Executive Government of the Commonwealth on matters relating to Aboriginal and Torres Strait Islander peoples. Parliament will determine how the Voice will operate, including its composition, functions, powers and procedures. As outlined in the Australian Government's official Yes/No pamphlet, there are arguments on both sides of the debate for voting yes or no. Voting is compulsory, and no one is forced to vote a particular way. It is up to each individual Australian to make an informed decision about whether they wish to make this change to the Australian Constitution. This video will look at the debate from a constitutional point of view. There has been significant disagreement among legal experts regarding the legal implications about the reach and powers of the Voice. The legal opinions in favour of the Voice proposal, the yes side, have said the amendment is a result of extensive consultation with Indigenous people who wish to be recognised in the Constitution as the first peoples of Australia, by having a voice that has a say on law and policies that affect them, treaty and truth-telling. Of these, only the Voice requires constitutional change. This amendment is said to be a modest change to the Constitution with a body that can only provide advice to Parliament and the government. As detailed further by George Williams in a debate hosted by the Sydney Institute, the amendment provides recognition in the Constitution, listening that leads to better outcomes, and a modest change to the Constitution. The legal opinions against the Voice proposal, the no side, have said the amendment is significant, as it adds a new chapter into the Constitution that will divide Australians, giving Indigenous Australians a permanent and additional method of influencing public policy. The scope and impact of the voice is uncertain, and the long-term impacts on our system of government are unknown. As detailed further by Chris Merritt in the same legal debate, the amendment is divisive, permanent, risky and unknown. At the end of the day, the Constitution is a document for all Australians that sets out the basic laws of governance in Australia. As Sir Philip Fish, former Premier of Tasmania, said in 1897, "We have cleared the way to federate as one people, and we are a united people, so soon shall we forget that we live not for ourselves only, but for others, and for the great country to which we belong." Our Constitution has a past and a future. It does not merely exist in the present. It is the basic law of Australia, and it is up to us to decide in the referendum what we want the rulebook for Australia to look like.